All rise. The Court of Appeals, Division 1 is now in session.
Thank you. You may be seated. We are here on our case number 1 CACV 180073, State of Arizona versus Michael Groh. Counsel, you all know that the appellant, you each are allowed 20 minutes for your argument. You may reserve any amount of time you'd like to use in rebuttal. The clock on the podium reflects the total amount you have remaining, including what you might have decided to reserve. We record these proceedings, so we'd be grateful to you if you would please give us your name and the name of your client when you approach the podium for the recording. We have reviewed the record in the case, the briefs, the cited authorities, and we've also discussed the case in our conference. So with that, Mr. Irvin, you may proceed.
Thank you. May it please the Court, Patrick Irvin for the State of Arizona, and with me at council table is Taylor Burgoon. And I hope to reserve five minutes for rebuttal. This case, it's a civil case that was settled by the agreement of the parties with language that pretty clearly shows that it was intended to be final. And based on that settlement, the court entered a judgment that did become final. And cases involving finality are always hard, or often hard, or either they're easy or hard. They're hard often because events happen later that make people think maybe we shouldn't have done that. Maybe something should have been different. And often you get people who are very sympathetic parties there. But finality is a very important part of the system in order that there be an end to litigation. In that sense, it's very similar to statutes of limitations, which come at the beginning of the process that set a time limit on when you can begin litigation. And the rules we have for finalities of settlements, finalities of judgments, look at the end. They certainly have a lot of relationships. The time limits in Rule 60 are very similar to statutes of limitations. And the need for finality, particularly when you have both a settlement and a judgment, is very strong. This doesn't mean that a party may not have remedies. In statute of limitations, if you're represented by counsel and you miss the date by a week or a day or a year, you may have a remedy against your counsel. In this case, at least, there's a very similar remedy available, which, as we mentioned in our reply brief, Mr. Groh has taken advantage of in terms of looking to his counsel, who he says did not give him very good advice back in 2015 in terms of both the criminal and the civil case.
In this case, though, we're mindful of our standard of review, which is abuse of discretion, and I'm wondering what cases can you cite in which the court has granted a motion for relief from judgment under Part 6, 60B or C6, and the appellate courts reverse that?
Your Honor, I disagree about the standard of review in a case like this, where our argument is the trial court missed the law and failed to apply the correct legal standard, both when it comes to a settlement that gets turned into a judgment and also just a settlement under Rule B6. But the cases that we've cited, the Republic National case, I believe reversed and reinstated the judgment, and that was based on several parts of Rule 60B, including 60B6.
Although the court focused on 4, I think, duress.
But they were both there, and many times these issues become tangled, which is why we're here. And in reality, here all of the challenges fall under 1 through 5. There's nothing extra that existed because the argument is there was duress for various reasons, but for the civil case, which again is a separate case, it's a civil case and the criminal case are separate, and we cite a lot of cases that point that out. But even to the extent the argument is that the plea agreement made me do it, that's duress. It's really nothing more than duress that I didn't have to do it. And again, there has to be an argument under contract law to meet it. It also has to meet the time limits of Rule 60B, which is it has to be brought within 6 months. By its nature, that's going to be a harsh result sometimes, because the way the rule is written says if you don't bring a question of fraud or duress or mistake or any other misconduct by the other party within 6 months, it's too late. About the only avenue to bring in longer is fraud in the court. And, to the extent there's an argument here that there was misrepresentation, there was abuse of process, those all fall under B1 to B5.
Have you found any cases like this one that deal with relief from a stipulated forfeiture judgment that was linked to a plea agreement?
I think several of the cases we cite from out of state, the Blakely case, it specifically refers to we will not, even if the civil settlement consent judgment was prompted by the criminal conviction, the court said we aren't going to set it aside.
Right.
The U.S. v. Bank of New York case, the argument was they were inextricably linked. The facts as to how they were linked aren't quite made in the case, but in both those cases, the court said the civil forfeiture is a separate case. The fact that they were linked temporally, the settlement and the plea may have come at exactly the same time. The conviction may have come at the same time. They're separate cases, and those extra circumstances from the criminal case are not an extraordinary circumstance under B6.
What about the fact that the plea agreement required that Mr. Groh to sign the settlement agreement?
Well, I think we need to be precise about that, Your Honor, and so we need to look at the plea agreement, and we quote it at page 10 of our brief. And what the plea agreement required him to do, it says the defendant waives any claim the defendant has or could have asserted in the civil cause action. And then in the same paragraph it says the defendant agrees to the attached factual basis addendum and the attached testimonial agreement. There are no additional agreements. It mentions nothing about a settlement. It does not say he had to agree to release the state and all of its employees from any claims he might have related to the investigation, which the settlement did. It does not say he agrees to indemnify the state from anything resulting from the plea agreement. It says he has to waive his claim to the property, which he could have done by withdrawing his claim that he had filed. It highlights that the settlement agreement went far beyond the plea agreement. Mr. Groh in his supplemental declaration says there were no negotiations about the settlement agreement. Multi-page documents don't spring from nothing. There was some discussion, or perhaps the state presented it and said sign it, and Mr. Groh's attorney told him you have to sign it. But again, that's the attorney giving him bad advice. If the attorney had pushed back and said the plea agreement says you have to waive your claim to the property, it doesn't say all this other stuff.
Well, but isn't the waiver of the claim to the property the key part of the settlement agreement?
Absolutely, in terms of the property. But all of the other parts, which the settlement agreement specifically says were entered into for purposes of avoiding the further expense of the litigation, avoiding other actions, they go far beyond that. And so the settlement agreement is separate from the plea agreement. And so
what would have happened if he wouldn't have signed the settlement agreement? Isn't that a two-page motion for summary judgment by the state?
Well, I think
to enter judgment?
If he had refused to sign the settlement agreement and then withdrawn his claim to the property, then the state would have proceeded. What's that?
What if he didn't withdraw his claim to the property? It's still summary judgment in a.
Well, the plea agreement required him to waive any claim to the property.
Right, so he couldn't contest it.
To the forfeiture, but he didn't have to enter into the settlement agreement based on the terms.
He couldn't contest the forfeiture, right?
Yeah.
So I'm just trying to figure out what was left, what he could possibly do other than withdraw the claim.
Well, he could have withdrawn the claim and then left the state to proceed with the forfeiture, which, given the time frame of this case, may have meant they may have never done it, because this case, the criminal case, started to fall apart right after he pled. He pled, and there was a co-defendant who pled too, Deborah Dupree.
I didn't know it was starting to fall apart for about 18 months, I thought.
Which is
a year.
Well, and that was part of the risk that went into the balancing of the settlement agreement and the plea agreement, showing how separate the cases were. The settlement agreement happened, I think, on July 1st of 2015 and was pretty quickly turned into judgment. But his plea agreement from April of that year was accepted by the court, but he was never sentenced. The sentences were put off and off and off, apparently because other defendants were doing things and the state wanted to see what happened. This would be a very different case if they had gone ahead and sentenced him and he was trying to get out of his criminal conviction. 18 months later, when the case had fallen apart, and I think that the Pinal County attorney was telegraphing that the case was falling apart, and he withdrew from his guilty plea. But that shows the criminal case was very separate. They were not joined to the hip. The criminal case lasted for another 18 months after the civil case was done and was final. Now, it's not hard to imagine things being very different. As I said, after Mr. Groh and Ms. Dupree pled guilty, there were other criminal charges actually brought against some of the other co-defendants that they were not subject to. So hindsight is great, but at the time this was entered into, the plea agreement and then the settlement, which, as I say, went far beyond waiving any claim to the property, became final. And subsequent events didn't change that. And that's where one of the errors that the trial court did under Rule 60b-6 was extending it and the relief to subsequent events in the criminal case, when the cases we cite show that that's just not an extraordinary event. Hopefully,
let's talk about what the meaning of extraordinary is.
Yeah.
Well, does the state contend that there was no injustice or hardship here? I mean, I want to try to draw out as a potential scale here, from no injustice or hardship to extraordinary, and see where you think it fits on the scale. Would it be a moderate, or perhaps even substantial, but not rising to the level of extraordinary?
Your Honor, and the facts are murky here. We argue a lot that the evidence doesn't support it. It's based on hearsay and many other things. But even accepting many of the things as true, which we don't, because they are based on hearsay, anytime there's a criminal prosecution that ultimately doesn't result in conviction, to the defendant's point of view, that's going to be an injustice. From the prosecution's point of view, it might be an injustice. It might have been a good try. It may be because the case fell apart for different reasons. But that's the way our system operates, is that there are prosecutions that don't result in convictions. And I'm not going to pretend that Mr. Groh got a good deal here. But in terms of the way the system worked, particularly at the time these agreements were made, it was a deal to resolve them all. As the cases talk about, they were trying to resolve the known and unknown risks. And
what you're saying makes perfect sense, but what I struggle with is 60v6. It's, and I know it's for by reason. I mean, it makes sense that it's very rarely used and upheld. There's not a lot of case law in it, but its very purpose is to sort of Monday morning quarterback, but way after the fact, and look back at everything that happened and then come up with. And I think I disagree with it a little bit, or I'm struggling with the notion that everything has to be contractually related. I mean, when the case law suggests this broad equitable power given to the court under any other reason justifying relief, that seems pretty broad. So why does it have to be tied to a contractual claim or contractual theory?
Because the decisions of this court say so. The Lamb case and the Emmons case and the Republic National case all say that to exercise Rule 60B, where there's a settlement or an agreement, you have to first look at whether the contract it can be set aside for substantive contract reasons.
Is it clear in Emmons there's a judgment?
I think there was a stipulated judgment. There was a settlement.
There was a settlement, but I'm not sure.
They moved to set it aside like the next day.
Right.
So it was very
but
quick.
I don't think there was a judgment.
Okay.
So I don't think this was a 60.
Yeah.
I don't think this was a Rule 60 case.
Yeah.
But even in Lamb's not a 60b6 case. Or do we know? Is it that one of those fuzzy ones?
It's one where we don't know, because it was but it was under 60B. And Republic National certainly talks about 60B4 and 60B6, and it makes sense. They all refer to discretionary setting aside of a judgment. And 60B6 is even more discretionary than others because it's less defined. But it does make sense, because if parties settle a case, they have weighed and balanced the risks. And as our supplemental citation pointed out, even equity will follow the law and enforce agreements because the parties have had a chance to do it. This is not a case such as a default where 60B6 comes into play a lot because there's a tension between the need to resolve issues on the merits and the finality of judgments. Here, there's not any tension between the need to enforce settlements and agreements and the need to enforce judgments. They both support the idea that there's no setting aside this judgment.
But that you assert a principle of law that you need to undo the agreement to undo the judgment, all stemming from Lamb. And in Lamb begins, since the claimed infirmity of the judgment was in fact the claimed failure of the settlement agreement, da-da-da-da-da-da, and then the court proceeded down that line. But the claimed infirmity, I mean, how is that so here? How is the claimed infirmity of the judgment the claimed infirmity of the settlement agreement in this case?
Because the settlement, the judgment is based on the settlement agreement. If it weren't for the settlement agreement.
Isn't the reverse true?
Yeah.
I mean, aren't
What's
they,
that?
isn't the judgment depend on the settlement agreement, and the settlement agreement depends on the judgment?
No, well, and
It's attached, it's
yeah.
incorporated, it was all spelled out, it's in the same document.
Well, it's presented to the court for its review, and courts may not turn away settlement stipulated judgments very often, but they can. And there are many times when settlements don't get turned into judgments, and yet the only way to challenge them is based on a contract. And that's why, I mean, these rules are going to apply to a lot of different cases, not just in this narrow forfeiture. That to the extent that somebody can argue something from another case made me settle it, a lot of cases get settled in sort of a global way. You have multiple litigation going on, they all get settled. As the Republic National case points out, that kind of sort of economic incentive isn't enough. That as long as you have a litigation alternative, is how the court phrases it, then you have the right to challenge the other side, both in the civil case and whatever other case might exist.
But getting back to Lamb, though, Lamb, the attack was the parties were mistaken about where the line was. That fundamental mistake was central to both the settlement agreement and the judgment. And that's what the court recognized. That's why the court said you need to undo the one to undo the other. But the claimed infirmity here is the unjust result of the judgment. That's not the claimed infirmity. There's not an attack on the settlement for that reason. Is there?
Certainly, because it was an agreement. To the extent there was any claim for injustice by the settlement, which is forfeiting the assets which were subject to it, that was resolved by the agreement where the parties said, we know there's risk of litigation on both sides, but we're going to resolve this case under these circumstances. And it could have gone differently. As it is, the criminal case fell apart, the civil forfeitures was final, and it had become final. And under the authorities we cite, it's a separate case, or it remains final. The injustice of the settlement is not something the court really is supposed to look much at. As I said, the cases we talked about. Well, that's your point, isn't it? Yeah.
That's your point. The Rule B6 would not support undoing the settlement agreement.
Yes.
So why can't that be litigated going forward? Let's say we send this back, say that we find no abuse of discretion, but that's all we say, and the parties take it from there.
And that may happen because the court did not set aside the settlement agreement, because the plaintiff did not ask. But given the authorities we cite, the Republic National, the court, without addressing the contract principles, should not have set aside the judgment, because it first had to look at those. And you can't set aside the judgment without looking at the settlement. Lamb actually lays out the process, a long footnote. They could have brought a separate action. They could have done a number of things.
Points out why that might not work. It's like
Would you
which came
agree
first.
that's dicta, that long footnote?
I think it's instructive.
Instructive dicta.
In terms of, but it highlights that there shouldn't have been a surprise when the state said, without addressing contract principles, you can't set aside the judgment. And the trial court erred by doing that, as well as I say, we certainly don't think it's extraordinary circumstances, a separate events in a civil forfeiture. And the case law is uniform on that, in terms of you make a deal, you run the risk that it'll go bad, it goes good, it might benefit, might not, but hindsight is not going to let you out of that. I'll reserve my last minute and a half.
Thanks. Ms. Adams.
May it please the court, my name is Ashley Adams, and I represent Tina and Michael Groh, who are present in the first row behind me. Your Honors, extraordinary circumstances mandate extraordinary measures. And Rule 60b-6, as this court recognized in Roll v. Janka as the grand reservoir of equitable powers, allows the trial court substantial latitude in setting aside a judgment when justice so dictates. In other words, Your Honors, the rule allows the court to do the right thing, which we believe Judge Sanders did in this case. We ask this court to affirm the trial court setting aside of the stipulated judgment for the following 3 reasons. Number 1, the trial court did not abuse its discretion in finding that there were, in fact, extraordinary circumstances of hardship and injustice by the Grohs being forced to forfeit everything that they own for a crime they did not commit. Number 2, the trial court appropriately considered the totality of the circumstances in this case, as Rule 60b-6 is not mutually exclusive. And finally, Your Honors, the trial court did not abuse its discretion in finding that the Grohs filed their motion within a reasonable amount of time.
What about if you're proceeding solely under B6, the unjust outcome? What about the notion that the exculpatory evidence that ultimately may have led the state to withdraw the criminal charges against all of them was equally available to both sides? How is this so extraordinarily unfair?
Well, Your Honor, the evidence was not available to both sides at the time in question. It was being represented to Mr. Groh that other defendants were going to be cooperating against him. That was, in fact, not true. And he didn't have access to those defendants because they, too, were represented by counsel and they were exercising their Fifth Amendment rights at the time. So there was no way to know or to independently verify this alleged cooperation. In addition, it was represented to Mr. Groh that the exculpatory evidence, which he maintained were on the computer servers, that evidence was destroyed, and that turned out not to be true. And so, in fact, at the time when he entered into his plea, that information was not independently verifiable. And he has, in fact, filed a separate malpractice action against his attorney at the time. However, that was done after the appeal in this case was filed. It was not before the trial court. And he also has a right to independently exercise different remedies. The fact that his attorney may not have thoroughly investigated the case certainly does not excuse the misconduct that the agent engaged in this case. And, Your Honor, in terms of the extraordinary circumstances, I cannot think of facts far more extraordinary than those that were presented by the facts in this case.
Have you found another case involving a motion for relief from a forfeiture judgment that was part of a settlement agreement?
Your Honor, this is a case of first impression before this court, and there have been other forfeiture cases. I have not found one with facts identical to this one. However, as the court recognized, this opinion should only be overturned if Judge Sanders clearly abused her discretion. And the courts give a lot of latitude to the trial courts because it is a factual totality of the circumstances type of an analysis.
What about the state's argument that Judge Sanders didn't appear to address the sort of the argument that your client didn't go after the settlement agreement from a contractual basis, attack the settlement agreement on a contractual basis, saying, here's why this contract is unenforceable, and therefore that's why we're entitled to have it set aside under 60b-6. What's wrong with that argument from the state?
Well, Your Honor, if you actually look at the record, we did ask for relief from the stipulation and consent to entry of judgment, which was attached to the notice of settlement dated July 1st, 2015. We attached that exhibit, which is Exhibit 9, to our motion. And as you can see, the notice of the settlement and the consent were executed together. So, in fact, he did seek relief from both the settlement and the judgment. There is nothing in 60B6,
Wait,
however.
go back and talk. So is it your contention that the settlement agreement has been unwound by Judge Sanders' ruling?
Well, Your Honor, in her order, she only set aside the stipulated judgment, but this is in fact a consent decree, if you will, whereby the judge had to approve the judgment. And as the Ninth Circuit in Hook versus Department of Corrections recognized, the proper remedy to seek relief from a consent judgment is through Rule 60C. And so that is the process that we chose. And it's ironic that the state has rated.
But you recognize that the judge explicitly said the settlement agreement stands.
The judge said that she was setting the case back to the place where the parties were before. I don't think she mentioned anything about the settlement agreement. But nonetheless, Rule 60B doesn't say anything about analyzing contract principles. And it's ironic that the state raises this issue because those contract principles are set forth in prongs 1 through 3 of Rule 60. Mistake, fraud, misconduct. And that relief was not available to Mr. Groh by this time because the 6 months had elapsed between the time he had entered the judgment, of course, and when he filed the motion to set it aside. And so his only recourse was to file a motion for relief under Rule 60B6. It doesn't mean, however, that the court in its analysis cannot consider all of the prongs in 60B as part of its analysis, as the court in Amonte Electric specifically held. And I believe that's what the court did in this case. She looked at the totality of the circumstances, and she found specifically that the settlement agreement was not independently negotiated, that it was part and parcel of Mr. Groh's plea agreement. She also noted that the criminal conduct that was the basis for both the civil and the criminal plea, that conduct never really happened, and the state has admitted that fact. The court also made very specific findings that the Grohs have in fact suffered extreme hardship and injustice. And that is true, Your Honors.
Well, that's true in any forfeiture case, isn't it? Any high dollar forfeiture case. So
I would submit that is true, Your Honor, of course. But in this case, this is not a typical forfeiture case where you would see instrumentalities of a crime being seized, or money or jewelry, things like that. They came into the Groh's house and they took just about everything that they owned. They took furniture, they took sports equipment, they took the washer and dryer. I mean, they even took a Mother's Day gift with the card still attached. And because of that, they also took the children's savings accounts and their own savings that they had in case of an emergency. And so this conduct has caused the Grohs an extraordinary amount of financial and emotional hardship, as we set forth in our brief.
But other criminal defendants, in the cases cited by the state, they've suffered equally, whether they've gone to trial and then been acquitted, or whether the case ultimately falls by the way and the prosecutor ends up dismissing a couple of years later, and meanwhile the forfeiture ran its course. I mean, what's the difference between those cases and this case? What's the linchpin? What's the thing that really makes this case stand out?
Well, I think, Your Honors, is the judge's finding that the settlement agreement was not independently negotiated and was inextricably intertwined with the plea. There was no such finding in any of the other cases cited by the state. And I don't think that there's anything in the record that could cause you to find that she somehow abused her discretion, which of course is a very, very high standard. In fact, the Supreme Court, the Arizona Supreme Court, in Gonzalez versus Mugen, just noted in April of 2018 that this rule creates a very broadly worded, and I'm going to quote, worded ground for relief, which, quote, we construe as investing extensive discretion in the trial courts. In signed petitions versus Chavez, the court noted that this is especially true when equitable considerations are at stake, because there may be factual and procedural conflicts that are best resolved by the trial court and should not be disturbed on appeal absent some fundamental error. And the state in this case has failed to show what that fundamental error is. There were specific factual findings made by Judge Sanders, which this court should not overturn. I would like to also point out that the United States Supreme Court in Buck versus Davis, as recently as 2017, noted that the court can consider a wide range of factors, including, quote, the risk of injustice to the parties and the risk of undermining the public's confidence in the judicial process. Now, I would like to address the state's contention that Mr. Groh did not present any evidence that the agreement was independently negotiated, because in fact he did. And on page 11 of our answering brief, we cite to ER number 113, and that is the supplemental declaration that was filed by Mr. Groh in support of his reply. And in that supplemental declaration, he talks about the fact that this settlement agreement was not independently negotiated. In fact, there were no discussions whatsoever about it, other than the state agreed to give him back his house because there was no equity in it, and he was forced to pay an additional $11,000 for things he already owned. But other than that, there were no additional negotiations, and that declaration was not controverted by the state. In addition, the state has contended that there is no evidence in the record about the misconduct on the part of Mr. Woods. Well, we submit to the state that that is a disingenuous assertion, and if the state, if there was some other reason why Mr. Woods was fired, the state certainly could have told us. Mr. Groh, in support of his motion to set aside the judgment in this case, filed a lengthy declaration, and he set forth in the declaration specific allegations of misconduct, including the fact that this exculpatory evidence was never produced. Mr. Groh also, in support of his motion to set aside the plea in the criminal case, set forth in his motion details about the misconduct. And I think it's important to note that Mrs. Mullins, his attorney, stated in the motion that, in fact, Mr. Woods was fired for that misconduct.
But the court didn't cite any of that in our case, in the forfeiture case, when it granted your motion, did it? The most. I mean, I looked to see about if there was overlap between the allegations in the motion for relief from, I'm losing track here, the plea agreement, and the motion for relief from the forfeiture judgment. And there's not a lot of direct overlap. Instead, the forfeiture filings and what the court said is simply that the state now apparently acknowledges he may not have engaged in criminal conduct. So I'm wondering, how can we find there was criminal misconduct and add that into the stack of things that might constitute extraordinary circumstances?
Well, if I understand Your Honor correctly, you're asking me whether or not the judge looked at the record to determine whether there was misconduct?
Yeah, prosecutorial misconduct,
yes.
I should have said.
Well, as we pointed out on pages 37 through 39 of our brief, during oral argument, Judge Sanders actually seized on the fact that in the criminal case, the state did not controvert the motion to set aside the plea agreement or the statements that were made therein. She asked a number of questions about it, which we quoted in our brief. And she seized on the fact that the state never filed a response to that motion to set aside the plea agreement. In addition, the state has never controverted Mr. Groh's affidavit. And if there was some other reason, like I said, that Mr. Woods was fired, perhaps they could have filed a declaration signed by the acting criminal chief at the time, who could have said there was no misconduct, he was fired for some other reason, but the state didn't do that. And in fact, the only thing that they did was dismiss the case. And I know they've made some statements therein, but Judge Sanders relied on the fact that those statements about misconduct were never controverted. A couple of other points that I would like to raise, Your Honor, and back to the Lamb case. The court is correct that case was not decided under Rule 50b-6. The court solely relied on the fact that the records seemed to indicate that there was only a unilateral mistake on the part of the property owner, not a mutual mistake, which is required under the prong of 60b-1. While the Redline case also, the defendant in Redline also asked for relief under Rule 60b-6, the court specifically found that the defendant did not allege any additional factors other than duress. In other words, there was not that extra thing like there is in this case. The extra thing in this case is the inextricable nature of the two agreements, as was specifically found by the court. There was also...
But Mr. Irvin says that's duress. That's effectively duress, the inextricable nature of the two agreements. What is your response to that?
Well, in terms of how it was negotiated in this case, there was certainly duress. I mean, when somebody's facing mandatory prison time, versus giving up your property, I think that's a very draconian choice, which by its nature is under duress. However, there were additional factors. He was allowed out of his plea agreement because of the misconduct on the part of the agent, as was alleged specifically in his motion to set aside. So we have misconduct, we have newly discovered evidence, we have duress, but importantly, the court found additional circumstances of hardship and injustice based on just the sheer amount of things that were taken, and also the fact that these agreements, or that the settlement agreement, was not independently negotiated. So in essence, Your Honors, the state is asking you to uphold a settlement agreement that was procured by fraud and misconduct. The state, even though it has admitted that these defendants did not engage in any criminal conduct, they're asking you to give them a windfall of $150,000 or more. And that's not truth, and that's not fairness. And the Attorney General, as a prosecutor, is supposed to be the guardian of truth and justice above all. And in this case, they've basically said, well, the misconduct on the part of our agent, that's not our problem, Mr. Groh and Mrs. Groh, that's yours. Well, that's not truth or justice, and I believe Judge Sanders recognized that very fact. This court must also ensure that justice be done, and we believe the only way justice can be done in this case is if, in fact, the stipulated judgment and the settlement are both set aside and the Grohs are restored to where they were before the settlement was entered. And so we would ask that you affirm the trial court setting aside of the stipulated judgment and settlement in this case. We believe that Rule 60C6 is an equitable remedy which allows you to do just that regardless of the settlement. We think that it is the right thing under these extraordinary circumstances of hardship and injustice.
Did you assert in your answering brief that Judge Sanders had in fact set aside the forfeiture settlement agreement?
Yes, we did, Your Honor. We talked about the fact that in our original motion, we had attached the notice of settlement with the judgment, which is dated July 1st. The stipulated judgment itself is dated July 9th, so we intended certainly to ask for relief from both because they were executed together as a consent decree, a consent judgment.
Okay, thank you.
Are there any other questions I may answer for Your Honors?
You're good.
Thank you.
Thank you. I think the argument makes clear that the claim to set aside is based on fraud, misconduct, newly discovered evidence, and misconduct by the other party, and duress. And all those are under B1 through 5, and they're untimely under the rule. And as with any time limit, including statutes of limitations, that may be unfortunate, may have harsh results, but all of the claims here are based on 1 through 5. The Gonzalez case that she mentions, decided last year, was a default case, but the court reiterated that there must be something other than 1 through 5. And in that case also mentioned the point that I made earlier about the tension between judgment on the merits and the finality of judgments that applies in a default case but doesn't apply here, where we have the equities actually of enforcing the settlement. Here, as has been mentioned, the cases we cite have many circumstances where people were found not just not guilty of the crime, but they were found that their behavior was not a crime at all because the courts found that their behavior was not criminal. And yet those settlements were still put in effect because they had agreed. And in terms of hardship, there's no hardship beyond what was part of the agreement. The agreement said, we give up these rights, we give up these claims. There's no hardship beyond that. And I'm not going to say that's not a hardship here, but it's what the deal said, and the deal is final.
Is it the state's position that the settlement agreement in the forfeiture case has been set aside by Judge Sanders' ruling?
No. As far as reading her ruling, I don't think there's any way to interpret her ruling as setting aside the settlement agreement.
Okay.
And so to the extent the settlement agreement is still there, that includes the waiver of any claim, releasing the state and all of its employees from any claims. And so that's still on the books, and that was agreed, and it wasn't part of the plea agreement. Thank you very much.
Thank you. Thank you to both of you for your argument. Thank you to all of you for your argument and your briefing. We'll take the matter under advisement and issue a decision in due course. Now we'll adjourn.